Kirk is not an attorney. This is not legal advice. This is to be considered for educational purposes only.
Share the group.
Welcome to Kirk's Law Corner Live with your host, Kirk Pendergrass.
Good evening, folks. We are live, Kirk's Law Corner Live tonight. Call-in show. I do have a couple people lined up to call in. We're going to be talking about some different things like truth, facts, and evidence. And the other caller we're going to talk about his case, which you guys will be in a new realm for you guys. So we'll see how that goes here in a little bit. So we'll start with Shar once she gets in here. I need to set this up. So follow Kirk's Law Corner, and then share, of course, when we go live. If you do the get notified first, or sometimes I see on there get notified when we go live. So if you click on that, it'll automatically notify you when we go live. So, and we have Christopher Hallett and John Gentry, of course, with us tonight. How you doing, brother?
Everyone.
Chris, we can see the top of your head.
The top of my, all right, let me see if I can change the camera angle without knocking everything over. Don't move, don't fall. If you saw this setup that I got going on here, you know, it's almost kind of like a balancing act, you know, it's like, you know, don't blow on it or it'll like, so, but, you know, hey, this is our little shoestring outfit we got going on until we can get better fundage.
Right. I'm pretty much set up over here pretty good. I got 2 laptops and the HD camera, all that good fancy stuff. Sorry. Yeah, I paid like, I think it was $49 for it at Best Buy.
You know, to be honest with you, I'm hoping to not have to do this very long. If you really want my honest opinion, I'd kind of like to not have to do it this way and be able to be, just standing there, whether, I don't care if it's in a courtroom, I don't care if it's in Congress, I don't care where it is. Just standing there making the argument, okay, are we done now?
Right, you know, it would be nice.
Can you guys get your heads out of your rear ends and, you know, go home?
You know, how less work we would have to do if the judges actually just followed the law. I mean,
there's a novel concept.
How many attorneys would be out of business?
Ironically, though, this is not an uncommon occurrence. You know, we laugh about it, you know, going back to the War of 1812. You know, as many times as the you know, the different federal judges have said, I don't know what the hell you guys are writing here, but you can't do it, right? And you know, the problem is we've reached kind of a tipping point in the scale, right? Because these certain factions, I won't go into casting aspersions on either the left or the right because not one is any better than the other. But they actually believe half of this crap they're saying now, right? So when you start to see, the different cycles of life, and it's like, you guys do understand that this has been attempted multiple times throughout history,
Yeah.
Yeah, I wanted to jump in here real quick because I noticed Connie jumped in here. She's an attorney here in Nashville, and I've been dying to get a hold and talk with Connie. So, Connie, something we're working on. I've got a couple of cases in the Supreme Court. One of them is demanding reform in the state. The state has enacted statutes that are repugnant to our federal constitution. They're just actually appalling statutes that were enacted for the purpose of usurping constitutional rights. So in that case, I'm challenging those statutes, and we're working on another project. I added you as a member. We've got 5,000 people in 2 weeks that we've picked up in this group, which is an astounding growth. It's all word of mouth, and we're bringing a case in the United States Supreme Court, original jurisdiction, demanding reform of all of the states, because all of the states have enacted unconstitutional statutes. All of the states provide no means to address grievances against the state. And so we need to have some means to address grievances when our rights are violated, specifically our right of due process. So I hope Connie, I hope you're still on here, and I hope you'll give me a shout. You can message me and I'll give you my phone number. I would love to talk to you. So back to you guys. Thanks for letting me jump in for a minute. I wanted to catch her.
All righty.
And if we've got anybody else from We the People that are on here, you guys drop comments, and I can't see the comments if you're dropping them on the We the People page. But if you jump over to Kirk's Law Corner and view from there, I've got the comments coming up live, and I can answer any questions you guys have about the project.
Okay, did you get our callers in yet?
Yes, we got one in there, and we got one in the waiting, and I'm trying to figure out where in the heck I may have to. Where's chat? I have to close. Okay.
Dolores made a comment that we could generate revenue for civil rights activism. I know for me personally, I'm not in this, if for money, and none of us are. We're here to bring about reform. That's where our heart is. Chris has been dealing with this his entire life. He's a victim of the system. Chris has been dealing it. I say 28 years because I met you 2 years ago. It's 30 years now, right, Chris?
It's pushing that. It will be that way in probably, it would be about late December.
Yeah.
Was when it first started for me.
Yeah. So we've got a lot of experience here. And what we're about is bringing reform and trying to unscrew this mess that they've made out of our legal system.
Well, basically, we know what they've been trying to do. They've been trying to do it since the War of 1812. Literally trying to change the perception of the words in the Constitution to mean, from what their intended purpose was, to what they're trying to construe them or misconstrue them to mean now. For example, domestic violence. When you read the language of American jurisprudence and domestic violence as it's written, okay, we're talking about a violence over the land, right? The land, domestically, right? Our domestic country, right? So to change that word domestic to mean inside your domicile, right? That's actually a misinterpretation or a misapplication of the words domestic violence as they appear in law. So when you talk about how they've gradually overwritten or tried to overwrite are a republic with some twisted version of a democracy, which is designed to fail. Everybody knows democracies fail. Everyone has failed it throughout history. Same thing with communism. I mean, it is what it is. You know, I mean, if you don't want to read the history of it, that's your prerogative. But this experiment, you know, the American system of government as a republic, yes, we've tolerated a lot of it, and that's our own fault. But when you actually look at the law, the way the law is written, and the practice of law, the way it's written, which meaning American jurisprudence, what they're practicing is not American jurisprudence.
Yeah, and let me jump in on that. Is that this is quite easily explained on how we got to here. I'm going to answer a question real quick. Somebody asked, "Do we have all 50 states and we the people?" Yes, we have all 50 states right now, and we've got our strongest states right now are Ohio and Alabama are where we're strongest at, and then we're coming in with like New Jersey and California are pretty strong as well. Lot of people coming out of those states, and I think that just has to do with you know, we don't have a lot of members from California and some of the other states around here. So you know, this is a secret group, so you have to be invited. So as we reach somebody in California, you know, then those Californians will reach out to other Californians. I think we got a pretty good showing in Colorado too, as well. But talking about how the hell did we get here? So in 1949, attorneys made about as much money as a plumber, and their billing practice back in 1949 was based on the service that they provided, the ability of the client to pay, and whether they were successful, and even what the client thought they should pay. That's where we started out in 1949. We still had a pretty wholesome legal system around that time. By the 1960s, they enacted the time in money concept, which is the 6-minute billable increments that we see now, which is tenths of an hour. Once that started happening and they started billing time, then they kind of liked it. The lawyers were like, "Oh, this is great. You know, I spend extra time on this, working on this paper or working for this client. The more time I spend, the more money I make." So then the process progressed from there, and the legal profession started introducing all of these rules of procedure. And the intent of this, and this comes from Judge Malloy. He was an Arizona appellate court judge. He's the judge that wrote the Miranda rights opinion. And he wrote a book that was a confessional. And he said that as they started introducing these rules to make less what lay persons could do for themselves. And so at that point, they started creating a monopoly of the system, and they started complicating the system so that people couldn't go to courts themselves, and they needed an attorney, and then they're billing by the hour, so they get paid more money. So as they complicated all these rules, then they're like, well, now what are we going to do? How are we going to make more money? Because this is a business. That's what the legal profession is now. It's nothing but a corrupt business. So then they started introducing new torts, and we went from caveat emptor, buyer beware, to placing all of the responsibility on the seller, and placing responsibility, you know, and taking it away from the individual and putting that burden on society and on building owners. And that's where we came up with slip and fall and product liability and all that crap. That all of those lawsuits, those are new product lines for the legal profession. That's all they are. And then they got a judge that's in there that's happy to rule in favor of these new torts because that generates more income for the profession. So what's happened now is, you know, they've thought up all of the stupid torts that they can come up with. And so what they're doing now is they've infiltrated the legislatures, and the legislatures are now are putting into law statutes for the single purpose of creating new torts, new crap that they can sue for. So, for example, California came up with this stupid one just recently about straws. You can't serve plastic straws anymore. You know, if you give it to them without asking, you get fined. Well, yeah, you also get fined, but you stand the chance of 6 months in jail, which means you know, now people got to go hire an attorney to keep them out of jail. And that's the whole purpose of that law. It's not to keep the environment clean, it's to make the lawyers money.
Yeah.
So now you got the legislators
business.
doing all this crap. The other side of it is the vexatious litigation. And that's why the legal profession loves perjury. You know, so and they know that the attorneys are suborning perjury, and they love doing it, and the judges love it because these jokers just get paid more money. That's what our legal profession is today. Is it's a corrupt business model for the most part. Not all of them. You know, certainly there's probably a couple good attorneys out there and a couple good judges. Personally, I haven't met any, but I assume that there's some out there. So, sorry, I go off on that tangent. So
I want to remind people, tying right into what John's saying there, is this is not just family court. So if you'll notice, this is Kirk's Law Corner. The reason why I started Kirk's Law Corner, because this is about law in general, the entire parts of the law, all of it. Okay, so for those of you that are just in the family law and think the family law courts need to be fixed, I really need you folks to open your eyes a little bit wider and look at the bigger picture, because the bigger picture is it's the entire establishment. Our form of government has been hijacked. We are no longer acting under Republican form of government, and that's the reason why we're doing this suit here. Writ of certiorari, okay? It's because we are not acting our states are not acting in a Republican way. As a republic where we are self-governed, we are the rightful masters of the law. We are supposed to be dictating to the servants what they can and cannot do and how they will act. And that's that policy that we are supposed to be making, because, you know, these are supposed to be from the pool of we the people. All these positions, whether you're an elected official or any kind of an employee, if you receive payments from disbursement payments from the Department of Treasury, you're an employee. You're a servant, public servant to us. Okay. So the servants don't tell the masters what the law is, and the servants most definitely do not dictate to the masters how they are going to act. No, I don't think so. So this is the part that, you know, we're going to be addressing is this policy. And when we go through the statutes say, like what I've been digging through, is it's policy. It's the policy of the state. Well, again, we've talked about this before, this reverse engineering of making legislation based off of an agency's policy. And I clearly have seen it in my own Idaho code. It's the policy of and then the legislative branch says it's the policy over here, but it's not the policy of Idaho. It's the policy of Department of Health and Welfare. And then, like, suspending driver's license. Since when does one Department of Health and Welfare, one agency, have the authority to tell another agency how to operate and what they can and can't do over there? That's like McDonald's telling Wendy's what they can and can't do, and that you're going to be subjected to our policy over here under McDonald's, or McDonald's telling, let's say,
Subway,
the public transportation, you know, buses and the trains and planes, trains, and automobiles. Okay, McDonald's is going to start dictating who can ride. If you don't, you know, buy my hamburgers, you can't ride the train. You can't ride the subway. It's just completely illogical. I mean, it almost hurts my freaking brain to think that way. I mean, I'm not kidding. It's like, how does Department of Health and Welfare dictate policy onto the people as the force and effect of law, affecting another agency?
when especially you can, like, for example, take exactly what I do. And I knew when I went into a week ago, I knew what the only question that guy had on his mind. And sure as shit, it had nothing to do with my kids, had nothing to do with how much money I make, nothing to do with any of that. You know what? He only asked me one question. Where did you go to school? The only question he asked me. I said, what does where I went to school, where I got my credentials, and how long I've been practicing have to do with the price of tea in China?
All right, so let's bring our first guest here on. Shar, are you with us? Can you hear us, Shar? You'll have to turn your sound down in the background there.
Let me get. Okay, here we go, guys. Can you hear me now?
Yes.
Yeah.
I'm going to look at it because I have a double of you coming on. I have a little bit of delay from what's coming through the phone and what I'm actually watching. It's pretty wild. I'm hearing it in double. So you guys are great. I love you guys. I mean, you have no idea how many people out here that you have changed literally their lives by coming in here and watching you. And I've taken bits and pieces of everything that you have in here, put them in the cases that I needed to use, and got kids home for real, guys. Listen, I didn't write anything for anyone. I didn't have to, but I had the knowledge to tell them what to do for the lawyers or public pretenders to do. We put them on notice if they didn't do it. And the word at the top is what? Fraud. So once they saw fraud, we didn't have to say the rest, meant that if they didn't do what was our demand that was told to be written, we were going to bring them down too. And how were we going to do that? We were coming right back in this room, getting the information we need and going back out to do it. And they knew we were serious. And we have, since November, I'm going to say, 9 kids home right in Ohio because we did that. And it's not a joke. It happened, guys. And it's from standing up and doing what you got to do. And I'm going to tell you that. I have people that I tried to bring in here to listen to everything you have to say. They come back out and say, Shar, I don't understand a word they're saying. It's okay, though, as I say. I throw little scenarios in here and there to break it down for them as simply as possible. But we still have the language that we need, and we still know where we are going, right, Chris? With that volcano, buddy. Mine's erupting, okay? We got to go. So once we translate it down and bring it down to as we could say, a civil level, because people, as you know, we are not attorneys out here. None of us are. And a lot of people will not understand the Latin, do not understand medical language, which is also Latin. So is law. So you have to break down Latin. So we break down the Latin, right, Chris? That's that. Right. So we have a few people out here that don't even know what pica is. Eat dirt. That's what I've been sending on a lot of messages to some attorneys, which they didn't know what it meant. Pica. Eat dirt. Because that's exactly what happened. They ate our dirt. And I'm so happy to bring it back to you guys and let you all know where we got it from and how we did it. And we're going to let everybody else know where we got it from and how we did it. And it's right here at Kirk's Law Corner. I've been talking with Chris behind scenes a little bit. I talked with Kirk behind scenes a little bit. I jumped in with John with his 50 states, brought a lot of people in from Jersey. We are serious. We're not going to take this from no one. I'm going into D.C., and they're going to hear me in D.C. also. We're going to be shooting live from D.C. I'm doing Philly Slim's. It's the 50-50 parenting, and I booked it. I'm going in. You can't shut me up. At this point, we are working together, and what you're doing, what people don't realize is, you see that big packet that's behind John? These guys here know that packet, okay? What they're asking you to do is trust it. There's a difference, okay? Trust. Now, one thing you have to be approachable, okay? If you're not approachable, there's nobody trusting you. They're not only approachable, these guys are real, okay? There's a difference out here, not real and real. They really are working their asses off, butts off, sorry guys, with that packet for 50 states to come together to bring it down, as Kirk would say, from what? From the Magna, okay? We're going to take it backwards now, guys. Let's go backwards, right? We're going to go all the way back to Christopher Columbus. That's that. We're going to take it back, Kirk? Is that what we're doing? Let us know.
It would go clear back to Sir James from 1603. 1603, Sir James came over from Great Britain and established Jamestown, Virginia, with the first charter of Jamestown. That's why it's called Jamestown. Sir James brought his fortunes with him and his bloodline with him and all of his servants. And that's where America got its start, our English America. And they brought the Magna Carta with them.
Yeah, 12th century, we realized that judges cannot be trusted to dispense fair justice, and that trial by jury is necessary and critically necessary in the process. And we are absolutely deprived of that right in many civil court cases, if not pretty much all of them. We say, well, I'm being treated unfairly. I'd like a trial. I'd like a jury trial. Well, no, you can't have one. This is an administrative court. You can't have that trial by jury. So, Shar, that's the primary redress that we are seeking in the United States Supreme Court. Our federal Constitution says that in any civil matter exceeding $20, we have a right to a trial by jury. Most state constitutions guarantee a jury trial in any civil matter, no matter how much, if it's $20 or if it's nothing. And we can't have that. We're deprived of that right. They have taken that away from us and made the Constitution null. That's the primary redress we're going to seek in the United States Supreme Court.
Right. And see, this is what I always say, the brilliance behind the American jurisprudence. When you look at the way the Constitution is built, okay, it's like a science. I mean, it really is. So when you, like any other science, you can examine it, you can break it down, you can pull it apart, you can do all kinds of different things with it. And the only way it doesn't work is if it doesn't have all of its components, right? And I found in my work with studying the Emoluments Clause, I found the deficiency in that science that's why I said, when I said at the beginning of the show, how they've changed and perverted the meaning of the words domestic violence, right? Mm-hmm. So they did the exact same thing by excluding the word emoluments from the practice of law, right? So what they have done is they're leading people to believe that they have, we have this progressive, forward-thinking thought mentality that we're going to ram up your ass, right? No. What they've done is they're not going forward. They've gone backward. I mean, these tricks that they're pulling are so old, they're new again. It's like a bad joke,
Yeah, these guys, I've been hearing this crap, even in We the People group. The appellate courts have ruled this, that we don't have to provide jury trial in certain civil matters. We can take your kids without a jury. We can take your property without a jury, And people just sit back and say, well, the Supreme Court said so, or the appellate court said so, and they just accept it. That's just the opinion of a judge who is unwilling to enforce the law. And the law is
cloak, right?
That's the only law in this land is our Constitution. These state statutes, they're guidance documents, just like their court rules, all of that crap. The law is our Constitution.
Actually,
people have forgotten that. We've been so removed from the intent of our founding fathers. People don't even understand that, nobody, I can tell you, very few people look to their state constitutions. I know Kirk does. I know I do. And that's, our state constitution's got some really great stuff. Jefferson said Tennessee's was the least imperfect and the most Republican of all constitutions out there. And Idaho has some good stuff too.
The thing that we need to understand about constitutions, okay, constitutions are basically, in legal definition, okay, government is the figment of the imagination, and constitutions are the internal dictate of the mind. So we take that internal dictate of the mind and that the conscience of government, and we put it on paper. That's a constitution. That's how we institute government. Okay, the Constitution itself is not actually law. I mean, it is law. It's due process of law. The law for bringing things into being, like the president, the governor, the representatives.
I'm going to give you an example.
Hold on. That's that kind of law. Then you have the common law. That's bills of rights. And every single one of our state constitutions will have a Bill of Rights. Right here, Article 1, Declaration of Rights. That is law. And even in Black's Law Dictionary, you look up the word right, and the first part is law. Rights are sometimes law. Okay, that's because rights are have a correlative duty. So where you have rights, and if I were a police officer, I have a duty not to trespass the law and violate your rights, because that is the law. And property, if we look up property, our rights and aggregate of rights falls under the term property. And in fact, it's one of the first definitions of property. Property isn't always, this pen. Some property is real property, estate. That's your home. Okay, then you have personal property, but property in its inception in the beginning, back when it was originally, when we talk about words and phrases, we have to go back to when that word was first used and what it was when it was written, okay, and what it meant back when it was written by who wrote it. So back then, property actually was rights, and that's the reason why it's just life, liberty, and the pursuit of happiness, because life, liberty, and pursuit of happiness falls under property.
And much of the constitutions are based in natural law, from our Christian principles that our country was founded on. And this is another redress that we're seeking in the people group, bringing suit against all 50 states. Is we have no means to enforce our rights guaranteed to us in our state constitution and in our Bill of Rights. We have no means to enforce that. The state comes back and says, judicial immunity, sovereign immunity, Rooker-Feldman, they come up with all this crap. Well, okay, if all that's true, how do I enforce my rights? And you can't.
Right.
And a right that is not enforceable is no longer a right. That right has been usurped. And so what we're going to demand is that the states provide us some means to enforce our rights. Stop this false assertion of judicial immunity when we only seek equitable relief. Stop asserting sovereign immunity when we're trying to enforce our rights. And so that's another big one that we're going to ask the Supreme Court for, is to uphold the law, uphold our Bill of Rights, damn it.
Well, and here it goes beyond this, because talk about the things that they already know. Okay, this is like what Char and I were talking about one night. A judge who exceeds his office or jurisdiction is not obeyed. That's a maxim of law, which means it's a core concept of the practice of law. Mm-hmm. So in other words, if they're claiming to be schooled in the law, they're supposed to know this, right?
Right.
And because nobody has spoken it in the context that we're speaking it. This is how they're getting away with, like John says, oh, rats, they said no. No, I'm going to say yes. And here's how I say that.
This goes back to the earlier point that I made, is that they've monopolized the legal process.
Right.
No attorney will represent you in a case like this, and then they throw all these bull crap rules out there to make it difficult for everybody.
Right,
right. This old Marine figured out a way to get around all that crap. So.
Right.
I would like to point something out, guys. There was something that I was talking with Kirk about. I went to an attorney or a lawyer for a case. It was a very big case, and it still is, that I have going on. I had gotten hurt at a casino, and so when I went into this one lawyer, pretty big guy, and I brought him the case, and he says, "Well, there's a difference. There's unlawful, and then there is unfair." Okay, so. When you're going in, did they do something unlawful, blah, 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 and neglect, whatever. I said, I'm here for a lawsuit, a civil suit. He really wasn't even understanding what I was saying, wasn't even interested. More like, oh, well, so what? But then he was saying to me, there's a lot of differences in cases with people. You have unlawful and unfair. Now, you can go in anywhere and think what has happened to you is unlawful. And here, Kirk and I had just hashed out a case the other day we were doing, and then there's unfair. We tried everything possible to find unlawful, and we couldn't really come up with it yet to date. But when people are really thinking sometimes also, listen, sometimes things are just unfair. That people want to mistake as unlawful. Well, sometimes they get it right, as we say, and it is correct. And we want to bring that to people also.
Hey, Shar, I think I have your answer. Lex injusta non est lex. An unjust law is not a law. That's the core concept of practice of law, right? So when you're talking about lawful versus non-lawful or unlawful, if they already know that the statute, code, rule, and regulation is not lawful, that's where it fits. It fits in the language of the practice. An unjust law is not a law.
Right.
Right.
That's your answer.
Statutes,
if I understand the question.
City ordinance isn't law to begin with. Right?
Go ahead. Say that again.
Statutes, codes, rules, regulations, city ordinances, none of that's law.
No.
That's supposed to codify the law, and each agency is supposed to make their own policy that applies to the agents of the agency only. Not supposed to have the force and effect of law. City ordinances have to be based on law.
What law? They can never cite it.
The law.
Yeah. Well, for example,
independence. That one's actually where the law is laid down. When we look at the definition of law, law is that which is laid down, which is declarations, ordained or established, which ties right back into what we were talking about earlier. Right here in the preamble to the Constitution of the United States of America, it says, to ourselves and posterity do ordain and establish this Constitution. The Auto Constitution, in its preamble, okay, it says that we, the people of the state of Idaho, grateful to Almighty God for our freedom to secure its blessings and promote our common welfare, do establish this Constitution. So now we're down to what is laid down. Well, laid down is declarations. So laying down the law, you have to lay down the law first. Before you can even get to having a constitution, you have to lay down the law first. And that goes back to Emer D. Vattel, who wrote the Law of Nations, which our founders went off of like nobody's business, okay? Because that was the new thing at the time. Emer D. Vattel wrote that Law of Nations just before, this whole time period of the founding fathers Okay, the resistance and construction. I'll call it the construction of our nation. Because in order to create the nation, you have to lay down the law. And that's an ideology, the set of ideas. Those ideas are morals and principles. And that, my friends out there, that is called the law of nature. So the law of nature in this nation can be different than the law of nature in another nation.
Right.
And where that law of nature comes from, those morals and principles, that ideology comes from religion. I know this is a hard pill for people to swallow, but hear me out. It's not the actual practice of the religion that's going to church, tithing, and all that stuff. And this is right straight out of the Virginia Declaration of Rights. Okay, it's the fundamental principles, the morals, the 10 Commandments. And I have not ran into one person yet. I don't care if you're an atheist or not. Thou shalt not murder. Thou shalt not bear false witness. I have not found one person that thinks that that's a bad idea.
Well, the courts
There
think,
is, please.
the courts think it's a bad idea because they like bearing false witness. They love that.
So that's the law. That's
No,
actually the law.
let me put this into perspective, okay?
As it was declared.
Well, when we talk about what the government is, the Constitution is the thing that regulates the government, not regulates us. We tell them what to do.
Right.
So when we talk about what law, okay, what law is it that they're breaking?
Mm-hmm.
Well, I went through and I found it in goes all the way back to an ancient Roman law. It's called Lex Cremona. It's a law of the late Republic abolishing the acquisition of predial servitudes through prescription. So if you're out there and you're talking all that stuff about, yes, it's the birth certificate, and yes, it's all this, guess what the Lex Cremona covers? All of that crap. So it's not just, it's kind of like I always say, I can name that two notes, right? Lex Cremona. But that's just because I'm working this project from an angle nobody's ever worked it before. What I'm doing is I can clearly demonstrate at any one given point in time, what I always say, where the wheels came off the wagon. And from that point on, they're literally reverse practicing, okay, the statutes, codes, rules, and regulations is the stuff that we laid down to manage the government, right? So, because now they're taking and they're trying to use this stuff and say, well, this applies to you. What? No, it doesn't. This is what we did in the 70s to keep you guys from doing this crap. So when it came to how and why we codified the law, it was, if you betray your oath of office, it's a $250,000 fine per offense. So get your clicker out, right? And it's so simple, it's stupid. And that's the reason why it works, is because that's exactly the way it's designed to work. All I had to do was plug in the missing piece. It's been there all along. So like any other science, when you take that sucker and you build it, right? My favorite, one of my favorite philosophers is Aristotle. The whole is greater than the sum of its parts. As a fellow motorhead, Kirk, you know this, man. Every time you put that sucker together and you hit that key, you can smell that, fresh motor. Nothing smells better than a fresh motor once you just put it back together again and fire it up for the first time. Yes, this is the same thing.
Yep, there's a comment here, and Dolores Gowdy, she made a great point. We said it's okay for corruption because we allow it, and that's exactly right. We've been allowing this to happen to us. And I keep hearing crap about this case that we're bringing to the Supreme Court. We're not asking, we're asserting our right. Our constitutions guarantee us a right to reform the government. You can't say no to that. And if you do, that's fine, because we'll come back with a petition for rehearing. guys like us here, we don't take no for an answer. You know, they come in and say,
Nope.
well, you know, this state statute says you can't sue, you know, because there's this statute of limitations. Well, take that
Right.
statute of limitations and shove it because you don't have authority to set
An unjust
statute
law
of
is not
limitations
law.
on
And that's not a
enforcement.
just law. So stick it up your ear.
Yeah. And so I don't just say, you know, oh, okay, well, I guess the statute says I can't. I'm like, no, the law is unconstitutional. Now I get into the Sixth Circuit and they come back with this misconstrued rules of procedure. And I'm like, no, try again, guys, because you can't misconstrue rules to suit their purpose.
That's a Ninth Amendment violation. That you cannot deny or disparage, right? Or misconstrue rights retained by the people.
Right.
You can't do it. That's the one thing you can't do, Judge.
Yeah.
So quit doing it.
So Dolores had a great point there. It's because we allow it and we just accept whatever they tell us. We don't take the time to learn the law. We don't take the time to enforce our rights. And so they, you know, look at where the hell that's got us, you know? So I think it's kind of time to stand up and band together as a people and demand reform. And that's what we're doing.
So let's bring on our other caller here. His name is also Ted. Are you with us, Ted?
I am with you. Can you hear me?
Hey, what's going on, Ted?
Hey, thanks for having me, guys. What a great show tonight.
Thank you. Welcome to the show. So where do we want to start with your situation?
Well, I first want to say I love what you guys are talking about, not taking no for an answer and mustering our way through what's going on here. I've actually become a criminal defendant so that I could figure out, you know, more of this stuff and how it works and what we're supposed to be able to do and what we can do and what we can't do and how they treat us in court is bizarre. Just to bring everybody up to speed, I'll let everybody know what's going on. I'm facing 16 to 20 years in prison for selling marijuana in Michigan. And I'm licensed by the state of Michigan as a medical marijuana caregiver / practitioner. And I had some police officers shop me for marijuana as a product. And every state that has some form of legalized marijuana has to do it in such a way because selling marijuana is obviously still a federal crime, being that it's a Schedule I narcotic at the federal level. So Michigan has a clause in its Michigan Medical Marijuana Act. It's Section F that says registered primary caregivers may receive compensation for the costs associated with assisting qualified registered patients in the medical use of marijuana. So in Michigan, what we're allowed to do is we're allowed to sell the service part of marijuana and not sell marijuana itself. So what happened was we got some police officers here. Instead of tracking down heroin dealers, they're after medical marijuana caregivers here in Michigan. They went out to the state of Michigan. The state of Michigan issued them fraudulent Michigan medical marijuana cards so that they could go out and shop for marijuana as a product and then arrest people for selling an illicit narcotic.
Tricky Ricky, huh?
That's part. See, this is part of what we had talked about before. Is that now? Wait a minute. You're giving a fake ID to a police officer, and then you're employing. This kind of sounds a lot like an emoluments violation.
Oh,
a police officer who's already employed, and then sending him out there to set Ted up with this fake ID.
Right?
Who's committing the crimes here?
That's called entrapment.
Well, in Michigan, it's a 4-year felony for people to acquire controlled substances under misrepresentation, fraud, forgery, deception, and subterfuge. And that's exactly what issuing a police officer's fake identity the medical marijuana cards are not issued in the name of the police. Even they're issued in the name of the police fake identity. Their fake persona is actually issued the credentials. So
think about that, Chris. How many crimes, John? How many crimes is that being committed just to try and set Ted up?
Yeah.
Well, Ted's not the only one that's going through this, and that's part of the reason why I get a good handle on it today, because my trial was supposed to be done by now. It's been more than 6 months since my arrest, and we haven't even gotten production yet. So it's really difficult to know when this is going to happen. But we've got my lawyer quit the other day, actually 3 days ago, because I think he was threatened. Not sure how or why. Before the last hearing on April 24th, there was a private meeting between the judge, my lawyer, and the county prosecutor. And after that meeting, things were totally different with my lawyer. So I'm thinking that he was persuaded in some way to capsize my efforts here.
Well,
which goes right back to the point of what we're doing here is people need to get educated enough on what paperwork they need to file. So like in your particular case, if it was me, the very first thing would be lack of jurisdiction. Obviously, everybody does this. We know this now. This is what they do. Anytime we try to sue them, they file a Rule 12B motion dismiss for lack of jurisdiction. So this is the same practice we need to do on them. And then the second thing is we have you can allege the crimes that they have committed, and that's in the treaties on arrest and false imprisonment. That summons, how to lay the complaint out, and the counts. It's all laid out in that treaties on arrest and false imprisonment.
right.
The forms are already there. And then a motion to suppress is what I would do. Suppress the evidence as illegally obtained because, one, we have fictitious names and ID. And they're also police officers. Wait a minute. You should know that you can't get a fake ID.
That's called
to go buy marijuana from someone who's licensed to do it. Okay?
Right.
Then the second is you're a police officer. You're already being paid to be a police officer. We can't pay you. That's an emoluments violation. Okay, that's embezzlement. Mr. Police officers out there that are involved in this kind of activity, that's a felony. Title 18, United States Code, subsection 643. It is what it is. To set a trap, because it's entrapment. So you're using forged documents to try to set a trap for these people. Why?
Who are properly licensed and credentialed to begin with.
Right.
Right?
Right.
All right. So pulled up the old evidence book while you were sitting here chatting. I'm going to read you a couple of things. First one is called a motion in limine. Okay? This is a motion to exclude or admit evidence often made before trial and usually heard out of the presence of the jury. Okay? Now, in a motion in limine, you have what's called a balancing test. The requirement that relevant evidence be excluded if its probative value is substantially outweighed by the danger of an unfair prejudice, confusion of the issue, misleading the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence. Now, the balancing test in your motion of limine is the key. And the reason that they will fail, or the prosecutor is going to fail in the balancing test, is because, like Kirk just said, we cannot give somebody false credentials to go out there and entrap you, a properly credentialed person, okay, who is following the rules of your practice as laid out by your state's Congress or the medical profession or both, or however that all got set up, right? So basically what you need to tell them is you say, hey, you want to prosecute me for doing this, you're going to have to go prosecute Congress, because Congress is the one who laid this down. They said I could do this. They gave me a credential that says I could do this. That's my argument for creating this, right? Congress gave me a credential, called it a fiduciary license, okay? And what that fiduciary is, it's in the paperwork, but I won't bore you with it. Basically, the long and the short of it is, the state of, at the time, it was the state of Ohio, said, based on my knowledge, my experience, the fact I took the relevant classes and passed the test first try and completed all the requirements, they gave me this fiduciary license to act on behalf of another person, right? And that said, I said, okay, we got a problem. I'm going to use that license and I'm going to fix this problem. And basically, one of the first things you need to pull up is Federal Rules of Evidence. It's called 403. That's where you're going to find the balancing test. So, making sure that there's nothing else in here I'm missing, because I think there's one other element. Here it is. The character evidence rule. This one's important as well. The rule prohibiting evidence of a person's trait of character to prove conduct in conformity there with on a particular occasion. So basically what that means is they're going to try to attack your character because you're selling marijuana, but you're doing it legally. But they're going to say, because you're selling marijuana, you're a bad guy or you're a bad actor. No, that's misconstruing through word salad, right? To attempt to get a conviction against you on which they have no basis to charge you.
Character assassination.
Right.
Well,
Which is completely
who's speaking
irrelevant.
there, guys?
Say that again?
Who was that that just said all that stuff?
Oh, that's me. That's Chris. I'm the troublemaker of the group.
Yeah, Chris. Well, nice to meet you, Chris. I love the way you think.
Nice to meet you too, Ted.
Well, just so you guys know, there's another component to what's going on here. I didn't become an enemy of the state until 2010. Up till that point, I was a happy home builder. I was traveling the country, building multi-million-dollar homes all over the place. And in 2010, I had a sheriff's department create a counterfeit deed in Kent County, Michigan, and I called him on it. And ever since then, I've become this enemy of the state kind of guy for pointing out the crimes of a sheriff department in their creation of a counterfeit deed, which is a 14-year felony here in Michigan. And that issue was never addressed by law enforcement. In fact, the only thing I've seen as a result of my having brought it to their attention was I just recently discovered in a discovery in this current criminal case that I'm involved in, the Michigan State Police have created a department called Michigan Intelligence Operations Center, Department of Homeland Security. And they created this document. It's called Officer Safety Caution. It's about me. And it says basically I'm a potential domestic extremist with violent tendencies, and just a whole bunch of other slanderous type stuff. And discovering this recently, I knew it existed because I felt its presence every time I talk to law enforcement. I can tell that they're wanting to, beat me up or throw me in jail forever or whatever. But I just wanted you guys to know that there's another layer to this onion, and it's called this officer safety caution. And of course, this is shared amongst basically all government actors. And it's like a secret slander thing. there are both civil and criminal allegations in this officer safety caution that have never been pursued, and we're talking about information that's put out by the police themselves, which essentially creates a false police report. Another thing about it is it's completely anonymous. It's not signed by anybody, and it's just basically got this narrative. I don't know if we have any Star Trek fans on the call, but it's kind of like a shared collective conscience, very much like the Borg.
Okay, now hold on here, Ted. For those of you in the family law, this may sound very familiar. It's a report written by some people making some claims. Does that sound familiar? Called CPS, Social Services, that report that happens and it takes away your kids. This is exactly the same thing. It's the same kind of report. And exactly what I've been trying to tell people, it is not just family court. This is a perfect prime example. And now here's something for you here, Ted, and the rest of you, okay? This is in my Idaho Constitution. This is under militia. Section 6, importation of armed forces prohibited. No armed police force or detective agency or armed body of men shall ever be brought into this state for the suppression of domestic violence, except upon the application of the legislature or the executive, when the legislature cannot be convened. Now let's talk about except upon the legislature or the executive, because we'll go back to Section 1, persons subject to military duty, all able-bodied males, blah, 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 blah. This is what they're, Section 2, pardon me. Legislature to provide for enrollment of militia. There's the limitation back on number 6, back to number 2. The limitation is right here in Section 2 that limits them what they can do. And again, the Constitution is the acts that can be brought into being. And this Constitution limits those acts. And we go back to importation. Okay, the root word is import. From the 16th century, okay, import means bring into being. Imagine that. It doesn't mean import that bottle of wine from France or from wherever and you bring it over here. It does mean that. That's one of the definitions. But back in the day, when we're talking about import, means bring into being. That's that legal maxim. Cannot bring a repugnant act into being. So this detective agency or this squad of people over there, okay, for those of you in the military understand squad, a squad of people, that's what that is. A squad of people running around making false reports against people like Ted or people in family court. Those are social workers or even the police officers, but it's the social workers that make that report. It's the same thing. The subject matter might be a little different, but it's the exact same process. These people are, I don't know, what would you call that? Private investigators? Detective agency?
Well,
that's what they are. They're making false reports and they're submitting them as truth, facts, and evidence without any evidence to support their claims. And they're not a party to the case. So what the hell are they doing submitting this stuff or, holding on to it for a later use?
Right.
My experience, Ted, in working with the courts is you can come in there like Kirk and Chris and give them rules of evidence and give them the law, but they're going to do whatever they're going to do. Unfortunately, that's just the way it is. Unless you get luck of the draw and you get a good judge who still follows the law. But chances are, that's not going to happen in trial court. So my advice is to challenge, everything, bring these arguments, get them into the transcripts, get copies of the transcripts, If you have evidence you want to present, get it attached to memorandums or motions, because they may deny you entry of evidence into the record. And so, sign an affidavit, get those exhibits file stamped, get them into the record. And then, at least in that way, you will stand a chance in appellate court. The best way to beat them, I think, in appellate court, opinions and laws can be interpreted, but the rules they got to follow. And so, learn those rules of evidence. And if they violate those rules, that's your best chance of defeating them in the appellate courts.
And there's also in the appeals court, tagging on to what John said, if you don't get your information on the record before you go to appeals court, you're done. So, for example,
yeah, you cannot.
What I would do,
appellate court, absolutely,
following the rules of procedure. Okay, what I would do, I would follow the rules of procedure under discovery requests. Yep. Being those people set you up, and that they have fake IDs. A request for discovery. I want their IDs. I want their oath of office. Oh wait, they don't have an oath of office. Where's their ID? What ID did you use? You need to properly identify yourself. And as the practitioner over there, we talked before the show. You made record of the ID that was brought to you. Now, if that ID doesn't match their identification, their oath of office, that is proof of their fraud upon the court. They're proof of willful intent and malice to set you up.
This is a great. That's
if
a great.
If they do not give you that is denial of exculpatory evidence, because that is evidence that can set you free, because it shows they're the criminals. They did unlawful acts by getting a false document, procuring false documents. That's a felony. Okay, and then come to you as a customer, a client, not necessarily a customer, but a client. Because you're a practitioner, you're administering medicine.
I'm going to help you out here.
Under false pretenses, they duped you. It's a scam. It's a scheme.
Yeah. So basically, what you're going to say is because you've been deceived, right? You had a legitimate business. You're doing legitimate business. Here's my credentials. I'm asking the law. Here's the maxim of law. The law helps persons who have been deceived, not those deceiving. This guy did the deceiving. I want his credentials brought forth because once that's established, res excipiendo fit actor. The defendant, me, becomes, or by plea or exception, becomes plaintiff. Well, what's the plea or exception? Well, the plea is me saying I'm legitimate. The exception is he lied.
Yep.
You now become plaintiff when you actually go back to assert your cross claim if you get denied an appeal and you want to assert in the Supreme Court. So by getting this on the record, when you get to the Supreme Court level, Supreme Court can't or nobody can say, oh, you didn't say that. You didn't get that on the record. You should have said that, because they'll pull that crap on you. So when you say, oh, yes, I did get it on the record, it's right here, it was submitted on this date, da-da-da-da-da, now they're stuck. Yeah. That's what when John says you beat them to death with their own rules, that's when you hit them with their own rules.
Yeah, and I want to go back to Kirk's point, because this was a really good point. Discovery, request for production of documents. I want every electronic letter, image, document, anything that you intend to use against me in court. And you go through that discovery and become familiar with it. And when they try to slip something in there that you don't have, and this applies to family court or whatever other corrupt proceeding that you're in, do request for production of documents. And when they try to slip something in there, objection, Your Honor, that was not provided in discovery. I wasn't aware of this evidence. And go back to them and say, don't just ask for the things you think you know about. Ask them for everything. I want their phone records. I want their emails. I want everything, because you don't know what you might find, so go out there and get everything you can from them in a request for production of documents.
What do you think about this, John? How about pay stubs? I want to know if you were getting paid during this time. Was this a paid job?
Yeah, so you're getting paid to deceive me. Right?
Unjust enrichment. Commit a felony, procuring false documents, and then going and coming to someone who is licensed to do this and bringing false documents while being paid as a public servant. That's, I mean.
Yeah, and then the other side of it, if they want to be corrupt, make them work for it at least.
Make them work.
As long as you can't be frivolous with what you're requesting. You have to be able to substantiate, because they're probably going to object to it, and so you'll have to go into court, on a discovery hearing and say, well, I need this because. So it has to be reasonable what you're expecting. Well, I want to see their phone records. Why did they have interest? Maybe somebody I know has been calling them. I don't know. I need to see who they've been contacting. I want their cell phone records. So, hit them with that. That was a great point, Kirk.
So one of my local people here, Robert Jones, he said the judge in court told me that discovery, they usually give you a little bit, then you ask for more, and they give you more, so it's not really out of procedure. No, not true. First of all, don't let the judge tell you anything. The judge is supposed to be the disinterested third party over there,
right?
Calling balls and strikes and declaring facts of law. Okay?
Here's what you're looking for. Remember, look for when they practice, if they put you in jail and they do a search of your cell, what's the thing they're looking for? It's called contraband, right? Let me tell you what contraband is. An object or material that is illegal to possess. A fake ID used to deceive you is not lawful to possess. That's contraband, and that's a crime for him to possess it, right? Mm-hmm. So when it comes to who's breaking the law here, right? You're a guy doing business. I'm sitting here and I'm reading my magazine, waiting for a customer to hit the door, and then watch this guy with this fake ID, this contraband thing here. Next thing I know, I'm an enemy of, I'm this, I got all this crap going on.
Right. So here's the thing. Doing discovery requests, and the reason why we should represent ourselves, I'll use that term, stand as your own, stand as the lawyer, one who speaks the law. That is what a lawyer is. You're out there dealing with attorneys. But when you are in charge of your own case, you know the facts of your case better than anyone on this freaking planet, right? So when you make your request for discovery, in this particular instance, if it was me, I would make the request for copies of those IDs.
I have those already.
Both, right. But in the request for discovery, so it's documented that I requested them. Not only that, when they request discovery from you, here you go. Here's the copies of what I registered as the person that came to me to for my services. Okay. And when those two IDs don't match, that is a proof. Then it's on the motion to suppress of evidence illegally obtained. And then here's the one I'm working on, which is that subrogation. Because in writing on that treatise on arrest and false imprisonment, those documents in there lay it out nice and sweet, how to write it all out. And then you could go and have I haven't figured this out completely. I believe there's some certain forms that need to be filed here. So I'm still learning on what needs to be done there. But if we can figure this out and how to do this properly, basically that's just right back to the legal maxim that Chris was talking about. You turn the case around. You always want to turn the case around. You want to become the moving party. And this is how you do it. And you file your counts and your claims and your counts, the violations of the law. Okay. And you itemize it. There it is. Procuring false documents. You brought a false document to me. You're a police officer. Here's your oath of office. That's all in the request for discovery. Where's your oath of office? I want a copy of that. I want a picture ID from you. I also want your business card, because those are the 3 things that you are required to have. Picture ID, oath of office, and a business card.
Well, I'd like to add this really quick. You guys probably have already imagined this, but the actual fraudulent medical marijuana cards issued to the police officers, fake personas, was issued by the state of Michigan. The Department of Licensing and Regulatory Affairs, which is a Department of Michigan executive branch here, actually created and issued these fraudulent documents, so they're culpable for the same crimes.
I agree. That would be conspiring, acting under color of authority in an attempt to bring fraud upon you, procuring false documents, using their position of authority. That's all an emoluments violation. Every single last one of those, every effort that they made would be an emoluments violation. Title 18, subsection 643, embezzlement. We cannot pay you to do that. We cannot use tax dollars to disperse from the Department of Treasury and pay these public servants to do this to us. That's just totally backwards.
Right.
And it's repugnant. You got anything else over there, Ted?
Yeah, I was just punching up that Title 18 section that 643 you were talking about. A couple more things I'd like to just add here is that the police officers, the sting unit or whatever you want to call them, spoke freely about the use of their fraudulent credentials in their police report, and then omitted any mention of these fraudulent credentials in their application for warrant.
So are you saying
efficiency of their process?
Tampering with documents to try and gain a conviction?
Ooh, you know what this sounds like? This sounds like the fake dossier that they used to spy on Trump, right? Am I wrong?
Along the same lines, eh?
I'm not familiar with that.
You don't know? You haven't been watching the news?
Yeah, I've been too busy dealing with my own news here.
All right, let me give you a little something here. All right, the DMC purchased from a Russian company called Fusion GPS a dossier, which is a report on activities, which is on the Trump campaign during the election. Okay. This is all bullshit. This whole document is all bullshit. The Comey Justice Department takes this dossier, this fake document, goes to a FISA court, obtains a warrant to spy on members of the Trump campaign, right? So when you start watching the what Congress is actually using, okay, what they're going through, this is hilarious as shit. I know that it's hard for you to wrap your head around this, but what you're going through is exactly what Trump is going through.
And how does that? So what's the complaint with that? So the warrant was obtained illegally.
The warrant was obtained illegally under false pretenses. They used false evidence to get a FISA warrant to spy on Trump. That's exactly what they just did to Ted. Yes, and they admitted it because they doctored the record.
Yes, I think that's a good, yeah.
A lie by omission is a lie, John.
Same process. They don't care who they use that process on.
Yeah.
They'll use it on the frickin' president.
Yeah. Dude, you should feel complimented they did that to you.
Ted, it is certainly worth raising the issue, and it gives you something else to appeal on. Was the search warrant obtained illegally? through false presentation to the court, to the judge in obtaining the warrant. I would throw that in there for sure and see if it sticks.
Yeah, well, that's exactly what happened. They lied by omission. They left out the fact that they committed a 4-year felony, and they conspired to commit a 4-year felony. And they premeditated this 4-year felony to come here and purchase drugs instead of allowing me to service them as medical marijuana patients and charge them for the associated cost. And the reason it left them, created an affidavit leaving this information out, makes the affidavit false, and everything that came after null and void.
Yeah, that would be what's that? Falsus in uno doctrine? False in one thing, false in everything.
Yep,
exactly.
And an affidavit is supposed to be signed under penalty of perjury. That's also a felony, to make false statements.
15-year felony here in Michigan, and I got the MCL memorized. It's MCL 750.423.
It's 14-year felony here in Idaho.
That's right. So
that's right. So yeah, that would be in your itemized deal there. I'll have to get that treatise on arrest and false imprisonment back to you. Did you get your computer situation fixed?
Well, no, not really. We did get the court to order on April 24th the return of all of my digital media. I was in the middle of creating a documentary on how screwed up the Michigan Medical Marijuana Act is here, and all of that information was on the laptops they stole. One of the questions I would have for you guys is, I'm constantly thinking about having to be ready for taking leave for interlocutory appeal and preserving my appeal rights. If anybody on the call here tonight would be interested in helping me with some of that stuff, I'd love for you to have my contact. But also wanted to ask you guys, I've built this motion which takes into account entrapment, the use of that officer safety caution to develop bias, and the fact that the officers committed crime in order to call me a criminal, all in a single motion. And because if they deny this motion, this is what I want to appeal. I don't want to get involved in defending myself with the Medical Marijuana Act, because that would be letting all of their indiscretions pass as water under the bridge. And I think this is what's wrong with our American system of jurisprudence today, is that people are not being appointed counsel that even knows about how to zealously advocate for their client. And by us taking the reins like we do, it's really important that we're doing the right things, and we're arguing the right points. And this is the point I want to go to appeal, is the fact that they presented the false documents, they lied, they committed felonies, and they fraudulent or false affidavit in application for warrant. Those are the primary core issues that I want to preserve for the first appeal, which here in Michigan, I've been told can last up to a year and a half.
Well, that motion to suppress the illegally obtained evidence, fruits of a poisonous tree. Okay, that's the exclusionary rule. If they exclude exculpatory evidence, so under the request for discovery, if I were to make a request for discovery for their copies of their actual ID, legitimate ID, you already have a copy of their fake ID. Have them produce that as well, because, well, I already have that. So who you say you are and who you said you were back then are two different things. So we got a conflict here. And who's that? Who are you? You're totally incompetent to be a witness. So we're going to have to suppress all of this. And basically what would end up happening is they don't have anything to go to trial with, because the officers can't get on the stand and testify because their testimony is already shot. It's been suppressed. They can't even take the stand because They committed the crimes. And now, if the judge were to dismiss my motion to suppress that evidence that was illegally obtained under the fruits of a poisonous tree doctrine, those would be appealable issues.
I'm just going to do a real quick little plug here, Kirk. I posted on the We the People page that I was going to answer questions here. So if you guys did have any questions, and I saw some new names out here. We're bringing a case, original jurisdiction in the United States Supreme Court, demanding reform, and we're asking people to join us as co-petitioners. So if you guys want to hear about that, or we can keep going with what we're going, but drop a comment in if you want to know about that, and we'll address it. Sorry, Kirk, go ahead.
No, you're good. I was actually going to see if you wanted to add into that what Ted was talking about there in the judiciary, not, allowing him to preserve those appealable issues.
Well, again, going back to what I said before, know the rules. Man, I'll tell you what, the biggest thing that you can do is just try to make friends with the judge. Don't be confrontational in there at all. Be as respectful as you can. Be submissive to him. Don't tell him, that the law, or be aggressive. Just say, I think this is what the law is. And speaking of demeanor that I'm using right now, don't get up in their face. Man, you're in survival mode right now. And you got to try to do everything that you can to preserve that. And so I think, that's the best advice I could give about dealing with the judge. Now, if he violates your rights, you'll deal with that in another court, or in a higher court. But in his courtroom, you kiss up, man, and hand him a jar of Vaseline and say, "Be gentle, man."
Right.
That's not the best thing I could say in there, man.
Well, I've even gone so far as to say, "Judge or hearing officer, I hate to be the bearer of bad news, sir or ma'am, but you've been lied to." That's the reason I submitted the paperwork and the evidence the way that I have. I don't want to waste your time. I know your time is valuable. So that said, let's just get to the end of this thing, and no harm, no foul, right? If there's a trespass here, it obviously is not in this courtroom, not yet, and I'd like to see it stay that way. And again, I'd just like to motion to dismiss the lack of standing.
And I would present it to the court that it's not that, there's all this false stuff going on, but that, Your Honor, there were a lot of mistakes that were made, unfortunate mistakes. And whether these were intentional or not, I don't know. But the warrant was obtained under false pretenses, and then and run through your arguments. But that's how I try to be gentle with them, man. As soon as you start saying these cops are bad actors, and all of that stuff, just say some mistakes are made, and let's not let this get out of hand. Let's address these mistakes and fix this problem, make it go away. That, try to be as accommodating to them as you can. You're in survival mode, so try to survive.
Word salad.
That's another thing too, is, we've talked about this before on the show, is, you're asking for the person that you're in front of, that hearing officer, magistrate, or judge, you're asking them to rule in your favor. So, it would behoove us to, I don't know, please them, not be jerks to them, because what's that, biting the nose off is to spite your face, or biting the hand that feeds you, and those kind of concepts and theories. Okay, that we know how corrupt they are. We do. But if you're wanting to get anywhere, the man in the black robe or woman in the black robe, okay, we've got to have some, back to civilized society here. you have to have some sort of civility, common decency, and respect. A lot of times we'll win that hearing officer, magistrate, or judge over.
Yeah. Can I jump on this real quick for a couple of questions on here, Kirk?
You go right ahead, John.
Okay. So a couple of people on here wanted to hear about this project we're working on. We have a group. It's a secret group. It's called We the People versus the 50 United States. And we're gathering people together from across this country, and we're going to go into the United States and demand reform. And how do we do that? So I've studied pretty hard my Supreme Court rules. Kirk and Chris know, like, that's one of my big strengths, man. I know the rules in federal court at all levels, district, appellate, and Supreme Court. So Supreme Court Rule 20, an extraordinary writ. To justify the granting of any such writ, the petition must show that the writ will aid in the court's appellate jurisdiction, that exceptional circumstances warrant the exercise of the court's discretionary powers, and that adequate relief cannot be obtained in any other form or from any other court. Man, that is where we are right now. And I have spoken to the Supreme Court about this case. And I said, that's the purpose of Rule 20. We are in extraordinary times. We cannot enforce our right of due process. Crimes are being committed or perpetrated against us under color of law. So we're going in under Supreme Court Rule 20, and we're going to file an extraordinary writ in the nature of mandamus. The primary jurisdiction in the United States Supreme Court is to make determination as to whether state statutes are constitutional or not. Every state has enacted unconstitutional laws with the intent of usurping our rights. So we are researching every state's constitution. We are researching every state's statutes. And we're going to list them off in this extraordinary writ, the nature of mandamus, and say, here's these unconstitutional laws in Alabama, Arizona, all the way down. And we want these unconstitutional laws rendered void because they caused us harm. They took away deterrent law. They granted immunities that are unconstitutional. And because those things happened, we were harmed in the court. So that establishes our standing. Also, our state constitutions say that we have that power remains inherent in the people, and they retain at all times a right to reform, an unalienable, indefeasible right to reform the government in such manner as we think proper. I think it's a pretty proper way to go in and do a federal lawsuit and ask the Supreme Court to unscrew what's happening in the state courts. I think that's a pretty reasonable way to do it. It's way better than taking up arms and revolting or going against the government that way. We don't want to abolish. We just want to fix a broken legal system. The redress that we are asking for in this case is that we have some means to enforce our right to a jury trial. So when you get into bad proceedings, what I want is whenever any litigation starts, both plaintiff and the defendant are handed a piece of paper and it says, here's what your rights are during these proceedings. Because 99.9% of most Americans do not understand what their rights are. So how can you enforce your rights if you don't even know what they are? So they're going to hand you a piece of paper that says, here's what your rights are. This is the redress. I want the Supreme Court to tell the states, this is what you're going to do. You're going to give them a piece of paper. And one of the things on there is going to say, if you feel that your rights are being violated, that you're not being treated fairly, that you can stop proceedings and demand a jury trial. And I think that redress alone gives us a fighting chance. It gives us an opportunity to at least go before our peers, before they take children, before they continue violating our rights. And I think if that mechanism were there, a lot of this crap would go away. Another redress that we're seeking is when we do try to enforce our rights by bringing lawsuit against the judge, then I want the states to be ordered to stop asserting sovereign immunity when we're only seeking to enforce our right of due process. Let us bring it to a jury. And so that's a basic overview of the process is we're going in there complaining about unconstitutional laws. We're complaining that the states provide no oversight of their judiciary or legal profession. And we're complaining that we have no means to enforce our rights. And the redress that we want is jury trial. We want oversight of the judiciary, and we want a means to enforce our right of due process. So I hope that answered your guys' questions out there. Tell people about this. We the People versus the 50 United States is a secret group. People can't find it. And I don't want trolls coming in and people that are, damaged by the system so much that they're not rational anymore. I want people who are committed to restoring the Republican principles that our country was founded on. So you guys that are out there, please go invite people to this group. They can't find us. The only way that group is going to grow is if we invite people in who are like-minded like us, that want peaceful reform of our government and our broken legal system, and then encourage them to go out and find more people. So we went over the going in under Supreme Court Rule 20. That gives us standing to go into that court. Our constitutional right to effect reform of our government gives us standing and jurisdiction to go into the Supreme Court. But we're going to back that up. I want to go in there with 250,000 people saying, we want reform and we're not taking no for an answer. And, if you don't want to docket us, we'll go to Congress, we'll go to the president, and you're going to docket this case. And if you decide against it, we're going to come back with a Supreme Court Rule 44 petition for rehearing, and we'll ask it again. We are not taking no for an answer. So go out, find people, bring them to the group, get in there, and let's get this thing done.
Yeah, it's Robert Jones. Again, this guy, I know him personally. He's an upstanding kind of guy. He tries to do peaceably assemble there at Department of Health and Welfare, the social services place. I've been there. We've chalked on the sidewalk. There was one time that I went that he wasn't there, but that was because he was under some sort of restraining order type thing. But this is a thing, and if you're going to get out there and be active and do this kind of stuff, it would behoove you to know what your rights are first. Okay, first, before you go jumping off the bridge, you kind of want to make sure you've got your parachute or some safety line or something. Know what you're doing before you jump. So for my local peeps, I am holding a law seminar on May 19th from 1 to 7 p.m. For those of you that know, that's in the private group also. So that's for my local peeps. I don't know if I'll record that or stream it later, or maybe, I don't know. But for those of you that want to get into that group, you can send either Kirk's Law Corner a private message, say, hey, add me to the group. You can send a private message to Christopher Hallett. You can send a private message to John Gentry. You can send a private message to me, or you can send a private message to anyone who is already in the group. If you're already in the group, please vet the people that you're adding. Don't just randomly just add all sorts of people. We don't want any drama in there. We have one line of focus here, and that is to redress the Supreme Court, our government, for grievances. And the grievance is the states are no longer a Republican form of government. Plain and simple. We are no longer self-governed. the masters have become the servants and the servants have become the masters. And that's an oxymoron and repugnant to our form of government. It's repugnant to the law. It's a declared act of tyranny. I don't know. I mean, it's beyond self-evident.
Yeah, right. Well,
It's beyond
reasonable.
self-evident that it's wrong.
Right. It's beyond reasonable. And
Beyond all logic and reason.
And, it's one of the things like, each of us kind of has our own little unique way of doing this. Now, remember when I started in on this project, the one that's behind me, I started this to point out where the deficiency was in the state of Florida's government. And what I discovered was that the bone that's missing from the Florida state government is an entity called the Department of State. Now, it has been created. The problem with it is it's not built properly. And because it's not built properly, it's not Republican in character or form. Now, this goes back to the problem that I had across state lines with the state of Ohio. State of Ohio, they have an inspector general, but again, both Florida and Ohio, they're not built. The whole system is the leg is kind of sort of there, but it's not even a leg. It's more of a nub. So until the leg is built with a foot where you can put weight on it and walk on it, all we have is provide for the common prosecution. We don't have a mechanism that provides for the common defense. I said, okay, I'm going to build one, and I'm going to give you an example of what it looks like. And they said, okay, fine, send us your reports, right? Which is why loss prevention, which is what I do, we don't just write pleadings. We write reports. We write findings of facts and conclusions of law based on decisions that are already made. Basically like, oh, yeah, I can't go into court and lie and present false evidence, the Hardwick versus Orange County of Rican case. Okay, good. I think I had that one covered, but I'll go ahead and cite it just because it's there, right? So, when we come to the fact that we can definitively show that we did come full circle, okay, and we're literally right at that cusp of treason or republic. Treason or republic, treason or that's like right where we are, right in there, that last little tick. So, and that's kind of why I decided to do this the way I'm doing it. They said, okay, well, I'm not just going to stand here and whine and cry and complain about what's wrong. I'm going to give you a potential solution that already exists in law, and it's just the proper methodology to do what is Republican in character or form based on what the Constitution of the United States says, to be consistent across the board. And when I started this, I said, okay, well, I'm just going to do one and see, just like I always say, throw at the wall and see what sticks. And the more it started to stick, I started to meet these guys, John and Kirk, and of course everybody else out there, and realized that, there's a bunch of us across the entire country that have this problem. And it was like, okay, now that I know exactly, number one, that I'm not nuts, that was, believe it or not, that was a big one for me, because I was starting to think I was a little loony. But the good news is now I know that. I know that that's not true. And I can start to share with you guys what I've actually learned in the work that I've already started to, some of the decisions that I've gotten out of federal courts across the country after this meeting coming up in Washington. I'll get approval about, hey, here's what we would like you to do. Here's what we'd like to see you not do, and then go from there. But remember, there's 3 branches, right? 4 if you include us. We're the most important one, but everybody always forgets that. But as far as the government goes, there's the other 3.
We're supposed to be the first branch. We are the sole
right.
arbiters of the law. We are the legislative branch.
Right. So when it comes to how do you redress government, well, what's the one thing that they absolutely love? They love a process. So if you can take them a process that works across the board, and it's not left, it's not right, it runs straight up the middle, there's a whole lot of political advantage for them to do this, right? So, again, you don't have to ask for your right to redress your government. That is your right to redress your government. All I did was I just created a new process just simply because I know how government currently works. So as strange as that sounds, that's kind of how I got started. And I've made some friends along the way, but I've made a couple of enemies too, and I ain't gonna lie about that. And
I don't think there's many people in the state that really care for me.
Right. Hey, high five,
Chad,
bro.
I need to say something out here. Chad, Kolb, however you say that, Colby. I'm not sure where you're at, but I can't remember what state you're in. But if he can post what state he's in there, he needs some help out there. Financially, he's in a very, very, very bad, rough spot. So I don't know if anybody can, help him out. I mean, I know I can't financially. I'm strapped myself. So, with the 7-hour long class, so what day I missed it. Oh no, this Cheryl, this is a private. This will be in person. This is a law seminar I'm going to present in person. So to my Idaho 3%ers. I'm trying to get the people educated, and this is part of getting local, dealing with local people and actually educating firsthand. I'm going to educate about E-Clause. I'm going to educate about we the people versus the 50 United States, the law, this kind of stuff here. Just Declaration of Independence, the Idaho Constitution, the Constitution of the United States of America, the Virginia Declaration of Rights, things like that. I mean, this is just...
It's interesting, Kirk. I had a little bit of education as a child on civil rights, very little. Basically just an understanding of, I probably got more from Schoolhouse Rock than I got in school. Not even in college. I didn't learn nothing about it in college. And this is a failure, or maybe it's a success of our government to keep us ignorant about what the law is. But it's unfortunate that we have to. Well, it's awesome. I love that you're taking your time like that, and kudos to you, man, getting out there and teaching a class like that. This should be taught in our education system, the importance of understanding what our rights are and making sure that the government doesn't trample all over them.
Right.
We do our little part here in Kirk's in the corner.
I mean, here you go. I mean, this is one of my favorite ones now because of Chris. Virginia Declaration of Rights, I believe it's Section 4. Yep, Section 4, that no man or set of men is entitled to exclusive or separate emoluments or privileges from the community, but in consideration of public services, which not being descendable, neither ought the offices of magistrate, legislator, or judge to be hereditary. And just so we all know that this is Virginia Declaration of Rights, June 12, 1776, as the theoretical foundation of all government. Jamestown, Virginia, 1603. This is why Virginia is the center of everything, because it's the longest standing state or colony, state at this time, because this is in the Second Continental Congress. And this is Thorpe 7, pages 3812 through 3814. This is published, folks. This is part of our ideology of laying down the law.
This is my favorite one. Thomas Jefferson, 1821. The germ of destruction of our nation lies in the power of the judiciary, an irresponsible body working like gravity by night and by day, gaining a little today and a little tomorrow, until all shall render powerless the checks of one branch over another, and shall become as venal and oppressive as the government from which we separated. Thomas Jefferson knew that this shit was going to happen, and he knew it was going to come from the judiciary and the legal profession. And he warned us. He warned us against it. And we just sat in stupidity and let it happen to us. And look where we're at now.
Well, this is the reason why we have the right to a trial by jury, to build right on top of that. The reason why we have that right to the trial by jury is also part of our all political powers inherent in the people. We have the right to alter, reform, abolish anything, capital T, at any time, is because when we sit on the jury, we have not only the power, the right, that's a right, okay? That's why they deny us that right to a trial by jury. That's why they've taken over jury instructions, okay? Giving jury instructions, we have the right to tell the jury that they have the right, okay? When you don't have an attorney or to be attorneying you, taking away that right, that property, and giving it to somebody else, the judge.
Yep.
Well, that's the
judge is supposed to be the third party here. So as the jury, we're supposed to keep the legislative branch in check. That statute or that policy is unlawful. That's why we're supposed to know the law. So when we sit on the jury, we go, wait a minute. Hey guys, what do you think? Do you think that statute's unlawful? Do you think that Department of Health and Welfare policy is unlawful? Do you think that EPA policy is unlawful? Do you think it's unlawful for a police officer to get a false ID to entrap Ted? Yeah, we think that's unlawful.
It's more simple than that. It's, hello, that's an obvious perjurous statement. You know,
Right?
We're not going to rely on that perjury. You know, we're not stupid. We're not going to.
Hey, no official with an IQ greater than the room temperature in Alaska. Sorry.
Right.
That's the germ of destruction. You know, working like gravity by night and by day is these jokers. They're confidence men, is what Chris calls them. Maybe not to the judiciary, but he, you know, he's a little more respectful than I am.
We got 5.
But you know, that's exactly that germ of destruction that Thomas Jefferson was talking about is, you know, they worked it in there a little bit at a time, you know, and over the last 40, 50 years, they've just corrupted the entire process, you know, and we have no due process anymore. We have despotism, no doubt. We have an aristocracy who is above the law. You know, you can't sue a judge, you can't sue a lawyer, and they, you know, because they protect each other.
Right.
That's despotism when you're subject to extreme authority and you have no means to seek redress. That's despotism.
Right.
And
That's absolute despotism, as declared in the Declaration of Independence, as declared in the Declaration for the Causes and Necessity of Taking Up Arms. And I would like to reiterate that, you know, we're a civilized society. We should be able to sit down and discuss this. And I like President Trump's plan, and we're winding down. We got less than 5 minutes now. We're 4 minutes. So with what President Trump has lined out with his executive orders going after serious human rights violations and human trafficking, if you read the human trafficking law, there is a section B to human trafficking. That is the debt slaves, the peonage, okay? That's the second part B of human trafficking. And Trump is all aware, he's all aware of this, okay? And then the executive order that he dug up from 1984 and made some amendments to the UCMJ, Uniform Code of Military Justice, for trying people in military tribunals. That's also was in the omnibus bill to give him money for the military tribunals. It's coming.
Right.
Okay? So
and when they take these oaths to the oath of office, believe it or not, these actors are under military jurisdiction. So take that for what it's worth. But I can tell you right now, if you swore an oath of office, myself included, you're under military jurisdiction. And guess what? As far as I'm concerned,
yep,
I'll tag in on that any day of the week, twice on Sunday. I look forward to it.
Well,
Because guess what? No matter what the outcome, it's over at that point anyway.
well,
So
right.
that's the goal.
Justice,
we're going to wind down here. And go ahead, John. Go ahead.
Justice Tecca, 1908. He said for the courts to not take jurisdiction when they should is treason against the Constitution.
Mhm.
And you know, I think it gets into the definition of treason. I think the Constitution says that it's an act of war, and maybe this is an act of war. I don't know, but when they send out people, law enforcement officers, armed, to deprive us of our liberty under color of law, it starts to sound like war against the people to me. And maybe that is treasonous. I don't know. But Justice Peckham said that it's definitely treason against the Constitution. And I don't know. I think there's a difference there between treason and treason against the Constitution.
It's a capital offense.
But if it is treason, then absolutely the military has jurisdiction over treason. We'll see.
I stumbled across that once.
It's capital felony treason.
Right. Because
Giving aid to our enemy, our declared enemy, declared acts of a tyrant, of a known tyrant. Those acts are listed in the Declaration of Independence. They're also listed in the Virginia Constitution. Okay? It's just, you have to understand those declarations lay down the law. The Declaration of the Causes and Necessity of Taking Up Arms, the Virginia Declaration of Rights, the Declaration of Independence, and then we'll throw the Magna Carta in there and the Articles of Confederation. So on that note, thank you all for tuning in tonight. I don't know if you got any last.
I got one last thing. There's a maxim of law that addresses what you just said, John. Enemies are those on whom we declare war, or who declare it on or against us. All others are traitors and pirates. So that concept or practice is covered in the maxims of law. So it's going to be interesting to see, because the reason I know that is because I did quote it in one of my reports. That's how I remembered it. So it's going to be interesting to see how they interpret that, because it's already before Congress. Remember that 14 pounds of paper that's already in front of them. So it's going to be interesting to see how this happens when we actually do break up this monopoly, because this monopoly is going away. Like it or not, it's gone. So on that note, that's all I have.
All right, folks. Well, hopefully Ted Fogg is awake over there. I haven't heard from him the whole show, so I know we've been rolling pretty good.
Yeah, right? See if he's over there.
I haven't heard from him.
Didn't he make you the host, though, didn't he?
Yeah, but I'm not in control of OBS or anything.
You guys can hear the music, right?
Cue the music! Cue the
Cue the
music!
music.
Hear it or not? You can't hear it?
No.
Okay, thank